legal at some point. Couple things. I do not have a legal background, but some trials and court proceedings do interest me, so this is why I'm here. I want to talk about this particular one right now. And you might see people refer to me as trending because I do have a primary channel called Trending at some point. All right, so we're getting started. We're going to start with the news story first, and I'm reading from my paper. So we're going to start with the news story first, and then we're going to get into the appeal that the Texas appeals decision that they made back in 1998, and also her current request for parole that has come up. So real quick hellos because I definitely appreciate seeing y'all. I'm so glad to see you. Hey, lovely Linda Gamble was first in the building. We have American Born, part of the Mod Squad with Linda Gamble. Kim Jones, thank you for liking the live. Cece, hey. Paulette, I see you. I see you. Hey. So we'll get started. This is going to be the format for a while. I don't know how long. This is going to be the format for a while. YouTube does not like me. They basically canceled out the whole YSL trial because I was showing the footage and it's crazy. So we're going to do a lot of reading for a while. So bear with me and, come in and out as you please. But I appreciate y'all being here. I really, really do. Okay, so Yolanda Saldivar is the woman who was convicted of Selena Quintanilla Perez's murder, filed for parole. 30 years after the death of the Mexican American singer, Saldivar, 63, filed a petition for parole in Texas. According to the Texas Department of Criminal Justice online records, she's currently in the parole review process and imprisoned at the Patrick L. O'Daniel Unit Prison in Gatesville, Texas. Saldivar was president of the singer's fan club and the manager of two of her clothing boutiques. She shot and unalived Quintanilla Perez at a Days Inn motel in Corpus Christi, Texas, on March 31st, 1995. The Como La Flor singer was 23. Saldivar was found guilty of first-degree unaliving, and on October 26, 1995, she was sentenced to life in prison with the possibility of parole after 30 years. According to NBC News, Selena's family fired Saldivar in early 1995, accusing her of embezzling money from the singer's fan club and boutiques. The singer's widower, Chris Perez, testified in court that they didn't trust her and removed her from their checking accounts, according to a 1998 court document from the Texas Court of Appeals. Saldivar has stated in the past that she did not intentionally unalive the singer, including in last year's Oxygen docuseries, Selena and Yolanda, The Secrets Between Them. In the three-part docuseries, she dismissed the claims that she embezzled money and said she was covering up Selena's extramarital affair. She, however, did not provide any evidence. The documentary received a slew of backlash from the singer's fans who did not want to hear what Saldivar had to say. The parole process begins about 6 months before the parole eligibility date for a first review and 4 months before the eligibility date. The Texas Department of Criminal Justice's website states Saldivar's file will be reviewed, including letters to support and protest, and a case summary will be prepared for the board voting panel. And her parole review date is March 30th. Okay, so what I'm about to read, this is gonna be, again, just put me in the background. This is gonna be long because what we're about to look at is the Court of Appeals of Texas in Houston, 14th District, their opinion that they formed back in 1998 when she filed for her appeal. And they made a decision October 1st, 1998. So they're going to go into detail about how they, came to their decision about her appeal that she filed in 1998. Yeah, what did you say? The safest place is prison for her. With these, yeah, I agree. And hey, Lacey, hey y'all. Okay, I'm looking at my screen. I need to be looking at this screen. But hey, thank y'all for coming in. Okay, so we're about to look at the Texas Court of Appeals decision. So it said, and anytime you hear complainant, that is for Selena. And if you hear, I think it's appellant, that's Yolanda Saldivar. But sometimes I'll try to interchange them just to keep it in line and let it make sense though. See, Lacey said if she gets parole, she won't be safe in Texas. She definitely needs to not stay in Texas. But there's a lot of Selena fans in a lot of places. Okay, So it says, appellant entered a plea of not guilty to the offense of unaliving. A jury found her guilty and assessed punishment at confinement for life in the institutional division of the Texas Department of Criminal Justice. In 17 points of error, appellant contends the trial court erred in. So this is what she's saying. Okay, so they're first listing only 1 through 9, but this is what it says: permitting the prosecutor to exclude veneer persons solely on account of their race, sustaining the state's challenge of a veneer person, denying certain constitutional protections because the state did not disclose impeachment evidence, admitting her written statement, admitting evidence of extraneous misconduct, denying a requested jury instruction and a special issue, admitting irrelevant and prejudicial opinion evidence as the punishment phase of trial, denying her motion for mistrial because of prosecutorial misconduct, and denying her motion for new trial because exhibits have been lost or destroyed. So those were her at least 9 points of where she's saying the court erred. And this is written from the point of view of the Court of Appeals. So it says, we affirm appellant, which will be Yolanda, shot complainant Selena in the back as complainant walked toward the door of appellant's room at the Corpus Christi Days Inn. Complainant ran from the room toward the lobby of the motel screaming. Appellant followed her in armed pursuit. Upon entering the lobby, complainant collapsed. Before passing out, complainant told motel employees that appellant shot her. In the meantime, appellant returned to her room. Shortly thereafter, she went to her truck in the motel parking lot where she was confronted by police officers. For more than 9 hours, appellant sat in the truck and threatened to commit self-unaliving. She eventually surrendered to police after conversing for several hours with members of a special hostage negotiation team. So this section says discriminatory exercise of peremptory strike. In her first point of error, appellant contends the trial court erred in permitting the state to exercise its peremptory challenges to exclude veneer members solely on account of their race. The 14th Amendment to the United States Constitution prohibits the state from using its peremptory strikes in a racially discriminatory manner. To codify and implement this prohibition in Texas, the legislature enacted Article 35.261 of the Texas Code of Criminal Procedure. Article 35.261 provides in pertinent part, after the parties have delivered their lists of peremptory challenges to the clerk and before the court has impaneled the jury, the defendant may request the court to dismiss the array and call a new array in the case. The court shall grant the motion of a defendant for dismissal of the array if the court determines that the defendant is a member of an identifiable racial group, that the attorney representing the state exercised peremptory challenges for the purpose of excluding persons from the jury on the basis of their race, and that the defendant has offered evidence of relevant facts that tend to show that challenges made by the attorney representing the state were made for reasons based on race. If the defendant establishes a prima facie case, the burden then shifts to the attorney representing the state to give a racially neutral explanation for the challenges. The burden of persuasion remains with the defendant to establish purposeful discrimination. If the court determines that the attorney representing the state challenged prospective jurors on the basis of race, the court shall call a new array in the case. The record reflects that appellant's trial counsel did not raise the Batson challenge until after the jury was seated and sworn. After both parties exercised their peremptory challenges, but prior to seating the jury, appellant's trial counsel requested an opportunity to make a record regarding the trial court's denial of his request for additional peremptory challenges. Appellant's trial counsel said, "I need to make a record with regard to that before they are seated with regard to the challenges that you denied me. We had to settle on this jury. I can make that record after you seat them as though I made it now." The trial judge responded, "That's correct." The trial judge asked if everyone had inspected the jury list. Both parties responded that they would like to inspect it. The jury was then sworn and seated. After the trial court released the jury, appellant's trial counsel objected to the state's use of its peremptory challenge as follows. Secondly, Your Honor, with regard to the jury selection, I just want to make a note that the prosecution has struck all but one of the African Americans that were on the panel. There's only one African American there. I'm gonna tell you now, the African Americans are with Selena, so that did not matter. We was riding for Selena too, especially us Texas African Americans. So don't even, it wasn't gonna matter. So right now, this is the defense attorney that she had during the original trial is saying that they had struck all but one African American off of the jury. It says they have struck 8 African Americans from the panel. They struck 13, 21, 26, 34, 38, 39, 48, and 49. We demand that the panel be quashed because of the way they did their striking, and they did it in a prejudicial way by striking racially. The prosecutor objected that the motion was untimely. The trial judge, however, questioned whether the prosecutor was present when appellant's trial attorney made the objection. After a brief discussion as to whether the objection was preserved, the trial court postponed argument on the motion until the next morning. The following day, appellant's trial counsel reminded the trial court that he asked to make objections to the impaneling of the jury and that the court permitted him to do so after the jury was seated. Once again, a discussion ensued regarding when appellant's trial counsel made the Batson challenge and whether the trial court permitted him to make objections to the impaneling of the jury, and the jury was seated. Appellant's trial counsel finally admitted, "Your Honor, let me say this. I had no inclination as to pass the challenge because I hadn't seen the color of the faces. And then, as they were seated at the time that they did, I knew that I should do that, and I made it." Without deciding whether the objection was preserved, the trial judge allowed appellant's trial counsel to renew his Batson challenge. The prosecutor once again objected, stating the challenge was untimely. When asked, the prosecutor declined the opportunity to state the reasons for striking the African American veneer members and objected that appellant had not met her burden to establish a prima facie case. After hearing argument, the trial court denied appellant's motion to quash the panel. All right. And if y'all are just coming in, I'm reading the 1998 Texas Court of Appeals decision when Yolanda tried to appeal her conviction. And then it says, hold on, let me make sure. The record shows that the appellant's trial attorney did not make a Batson challenge until after the jury was seated and sworn. Still, appellant contends the challenge was timely. She implies the parties discussed the Batson challenge during an unrecorded bench conference, thus explaining the trial court's response that the prosecutor who objected to the challenge was not present when the objection was made. Such supposition on the part of this court, however, cannot substitute for what was actually found its way in the appellate court, and that's Cochran versus State. Because the record reflects that appellant's trial attorney did not timely object, appellant's Batson challenge was not preserved for appellate review. Even if the Batson challenge was untimely, appellant contends her request to strike the panel based on a Batson violation was timely and preserved for review in light of Moss v. State. Moss is distinguishable from the facts of this case. The defendant in Moss filed a written Batson objection before the trial court called the jurors' names, but failed to obtain a ruling before the jury was seated and sworn. Thus, the objection was timely. The question before the Waco Court of Appeals was whether the objection was preserved for appellate review. That appellate court noted the purpose of requiring a timely specific objection under former Rule 52A of the Texas Rules of Appellate Procedure is to allow the trial court the opportunity to rule on the complaint and then to proceed with trial in a proper procedural and substantive manner. Consequently, the Waco Court of Appeals found the defendant obtained a timely ruling because the trial court could have granted a mistrial after impaneling the jury if it had found a Batson violation. Here, appellant did not make a timely Batson objection, therefore she did not preserve error for appellate review. We overrule appellant's first point of error. So that one's out. Okay. The next one, dismissal of veneer person on state's challenge for cause. In her second point of error, appellant contends the trial court abused its discretion in sustaining the state's challenge for cause levied against prospective juror Gwendolyn Harris. And in denying appellant's request for additional peremptory challenges, appellant contends Harris was a qualified veneer person, thus the trial court had no discretion to excuse her under Article 3516 of the Code of Criminal Procedure. The article provides a framework under which unqualified potential jurors may be discovered by the parties and excised from the panel without a need to resort to the exercise of a peremptory strike, and that's Butler v. State. Harris indicated on a juror questionnaire that she had been a witness in a criminal case involving her girlfriend's son. While offering her girlfriend support in dealing with the boy, Harris observed police officers make promises to the boy, which were later broken. She also indicated that her sister-in-law had been killed in a drug house several years ago. When asked if she would have a problem with officers testifying in court that would affect her rendering a verdict or interfere with her deliberations in this case, she said she had a problem with officers, but it would not interfere with her service as a juror in this case. Harris also expressed concern about her children and financial problems that would prevent her from concentrating during trial. Nevertheless, the trial court asked her to return for additional questioning the following day. Later, Harris expressed concern that her son needed her assistance because he had been suspended from school and she had to take him to see a psychiatrist the next day. She said, "I know I couldn't honestly sit up here and be a juror when I know I have a 14-year-old child that's having problems and I'm the only one that can help them." After the trial judge questioned her about the appointment, Harris asked, "So do I come back tomorrow?" As the trial judge considered whether to excuse Harris, the prosecutor challenged her for cause on the ground that she previously indicated she would have a problem with police officer testimony. The trial judge corrected the prosecutor, stating that her problem wasn't with testimony, to which the prosecutor replied, "It was officers themselves," she said. "I asked her if it would affect her as a juror, and she said it would." Appellant's trial attorney asked the court to note his exception and requested additional challenges. The trial judge replied, "Sure, I'll carry that." The trial court then excused Harris. Sexy Arian says she needs to be under the prison. When conducting voir dire, the trial judge has the discretion to excuse a veneer person under articles are listed. It says C. Butler. Under Article 3503, the trial judge, upon a reason sufficient to satisfy the court, may excuse an otherwise qualified veneer person from jury service. Under 3519, a judge must excuse a veneer person who suffers a disability sufficient to absolutely disqualify. Under 3516, a judge must excuse a potential juror proven to be unqualified by either of the parties upon a challenge for cause for one of many reasons enumerated in Article 3516. Excusing an unqualified veneer person under Article 3516, however, is qualitatively different from excusing a qualified veneer person for personal reasons under Article 3503. The reasons for challenges for causes enumerated in Article 3516 are, as a matter of law, the only ones which a party may request that a judge rule upon to disqualify a juror, while the judge may, in accordance with Article 3503, consider any other excusal factor with or without the prompting of counsel. Hardship and family responsibilities are excusable grounds under 3503. Although the trial judge did not state his reason for excusing Harris, the record clearly reflects the trial judge relied on this authority under Article 3503 and not on Article 3516. Harris prompted the trial judge for a personal excuse before the prosecutor exerted his challenge, and Harris was the potential juror. After the prosecutor challenged Harris, the trial judge corrected the prosecutor's misstatement regarding Harris's aversion to police testimony. Following some discussion in which appellant expressed her objection to the state's challenge, the trial judge excused Harris. Because the trial judge's decision to excuse veneer person Harris for personal hardship was an appropriate exercise of his discretionary authority under 3503, we hold that he did not abuse his discretion in excusing Harris. Accordingly, we overrule appellant's second point of error. So obviously, the defense attorney would have thought it would have been a better advantage to keep the potential juror named Harris because they may have had an aversion to police officer testimony, although the judge said they're excusing them because of their personal hardship with their 14-year-old son. Hey, Bama girl. Let me see. I guess I'm going to have to look over here. And hey, Sharon, my comments are not updating here, but thankfully I have a window over here, so I done missed my people. Lisi said, considering she survived in prison all these years, you're right, she's safer in prison than anywhere in the world. Michelle Tuff, good morning. Sharon Godbold, I see you. Professor Purple Queen, hey. Yeah, it's not, the chat is no longer scrolling over here, so I'll have to glance over there every now and again. Okay, the next point of error for Yolanda was her attorney is saying failure to disclose impeachment evidence. And we're going over her 1998 appeal. Leia's grandma says, Trending, are you going to cover the Naziah Harris trial over here? Yes, I guess I'm going to have to cover it by news article. I cannot show any footage right now. YouTube has denied. I was okay. Let me real quick. We're going to an aside real fast, but I do want to cover Naziah Harris. I'm gonna have to cover it via news articles and everything right now. I can't show any footage because YouTube does not like when I show trial footage or anything that I did not originally create. And you obviously later they'll let you do it, but if you're trying to actually monetize your channel, they don't like it. They call it unoriginal content. Doesn't matter how much of your own commentary you provide, it just doesn't matter to them. So in order for me not to mess up again with YouTube, I will have to cover it via news article. But I've had my alerts. I got to catch up to, well, I just, we'll go over the news articles and how they're writing it. And then hopefully, Lord willing, the sooner I get my channel monetized, we can actually look at some of the footage. They don't care once you're monetized, but they scrutinize the mess out of you when you're in the application of trying to monetize. So that's why y'all don't see the footage. But yes, I have my alerts on for Naziah's case. I am interested in that case. I have put some stuff out about her unaliving previously. So I definitely am interested, Leia's grandma. So yes, I want to cover it over here. So Lord willing, well, we're gonna do the news article either way, but I know it's even more interesting if we can actually look at some of the video too. So hopefully we'll get there. But yes, the answer is yes. Long answer, yes. Okay. Yeah, YouTube is weird, American born. Okay. I understand they don't want us to just not do anything original, but I'm like, that's the whole point of commentary too, though. Like, I'm not gonna go there with YouTube right now, but I had to come to grips with that a few months ago, and I've been trying to figure out my way forward after that. Okay, so the next point of error, failure to disclose impeachment evidence. In her third point of error, appellant contends she was denied the right to confront and cross-examine witnesses, the right to due process, and the right to effective assistance of counsel because the prosecution did not disclose impeachment evidence regarding the criminal history of a state's witness. Appellant filed a pretrial motion requesting the state to provide the criminal records of witnesses and specifically the criminal history of Norma Marie Martinez. After hearing argument on the motion, the trial court ordered the state to tender for in-camera inspection its record search on the state's witnesses and particularly on Norma Martinez. A computer search conducted the week before trial revealed no criminal history for Norma Marie Martinez. After the trial court rendered judgment, one of appellant's trial attorneys received information that led him to conduct a separate investigation of Martinez's criminal history. Using the name Maria Norma Martinez, appellant's trial attorney discovered Martinez had been convicted of theft in 1990 and at the time of trial had an outstanding warrant for her arrest on a second theft charge. Consequently, appellant filed a motion for new trial claiming newly discovered evidence showed the state failed to disclose exculpatory and impeachment evidence as required by Brady v. Maryland. The trial court denied the motion for new trial. So I'm guessing since that was a state's witness, they're probably saying, just like in the YSL trial, the state may have given the witness a deal to testify in this trial since she did have something looming over her. So maybe that's why. But it says the granting or denying of a motion for new trial lies within the discretion of the trial court. An appellate court does not substitute its judgment for that of the trial court, but rather decides whether the trial court's decision was arbitrary or unreasonable. To be entitled to a new trial based on newly discovered evidence, appellant must show there is, in fact, new evidence, both competent and material to the case, the existence of which was unknown to appellant at the time of trial. Second, appellant must show her failure to discover such evidence before trial or to utilize the evidence once discovered at the time of trial. Sorry, I said it like that was the period at the sentence, but it says, or to utilize the evidence once discovered at the time of trial was not a result of any lack of diligence on her part. Generally, new evidence that is merely cumulative, corroborative, collateral, or impeaching is rarely of such weight as likely to bring a different result. Appellant contends the newly discovered evidence of Martinez's criminal history is material to the outcome of the case, and the state's failure to disclose it deprived her of due process. A prosecutor has an affirmative duty to disclose all material, exculpatory evidence to the defense. A prosecutor violates the due process clause of the 14th Amendment of the U.S. Constitution when he or she fails to disclose material evidence that is favorable to the accused. Favorable evidence is any evidence, including exculpatory and impeachment evidence, that, if disclosed and used effectively, may make the difference between conviction and acquittal. Evidence is material if it creates a probability sufficient to undermine the confidence in the outcome of the proceeding. A reviewing court determines materiality by examining the alleged error in the context of the entire record and in the context of the overall strength of the state's case. The reviewing court may consider any adverse effect the non-disclosure might have had on the preparation or presentation of the defendant's case in light of the totality of the circumstances and with an awareness of the difficulty of reconstructing the course of the defense and the trial in a post-trial proceeding. Okay. At the hearing on the motion, the state's investigator testified that he searched for the criminal history of Norma Marie Martinez, the name Martinez signed on her statements to the state. Upon receiving the motion for a new trial, the investigator ran a second search under the name Maria Norma Martinez and discovered the theft conviction and a second theft conviction, which occurred subsequent to appellant's trial. The state claimed it had no knowledge of Martinez's conviction until it received the motion for new trial. Appellant does not dispute the prosecution's unawareness of Martinez's prior conviction or pending charges at trial, but questions the state's diligence in searching its records. The state's investigator testified that he did not search for Martinez's criminal history under any other name except Norma Marie Martinez because she was only a witness and he had no reason to believe she gave an alias. Yet, the Nueces County Sheriff's Department located Martinez's criminal history using the name Maria Martinez and her date of birth. Moreover, Martinez testified that the state never questioned her about her criminal history, and state investigators wrote her name incorrectly on police documents. The record reflects the prosecutor did not deliberately withhold impeachment evidence from the appellant. Yet the record also reflects the state made little effort to discover the information which it possessed in its own records. Therefore, we find the state breached its affirmative duty to disclose impeachment evidence to which appellant was entitled. Nevertheless, we do not find the conviction evidence to be material for impeachment purposes. So it looks like the appellate court agreed, or the Court of Appeals did agree, that they didn't make enough effort to check into that person's, the state's witness's criminal history. But they're saying at the beginning of this paragraph, it's not material though for impeachment purposes. So it says, and because of YSL, we were learning about impeaching statements. And if the state, I guess, did not directly ask her on the stand about, have you ever had a criminal history, or could your criminal history affect how you're answering today, to catch that person in a lie, there's nothing to impeach because that wasn't even brought up. That's how I seen with the YSL trial. Like, you have to make a statement and then you're challenged via impeachment, or they try to impeach the statement. So that's what it seems like. So it says, while appellant's trial counsel could have offered Martinez's theft conviction, if disclosed, to impeach her credibility with jurors, Martinez's inconsistent statements permitted appellant's trial counsel to accomplish the same goal on cross-examination. In a sworn statement to police on the day of the murder, Martinez claimed she saw appellant shoot complainant and run to her vehicle. On cross-examination at trial, however, she admitted that she saw appellant chasing complainant, which would be Selena, but did not see appellant shoot complainant. Instead, Martinez says she heard a shot and then saw appellant come out of the room pointing a pow-pow at complainant. She claimed she did not see appellant run to her vehicle, although she admitted she might have told police that she did on the day of the unaliving. Martinez also testified she heard appellant yell "bitch" at complainant, but admitted she did not tell police about appellant's epithet in her statement on the day of the incident. Moreover, Martinez described appellant's pow-pow as really big, like a cowboy pow-pow with a long barrel, while the evidence at trial showed the pow-pow to be a snub-nosed revolver. Furthermore, the state's case against appellant was strong. In total, the state offered the testimony of 33 witnesses and more than 122 exhibits. Of the 18 volumes of testimony in the guilt-innocence phase of trial, Martinez's testimony encompasses only 52 pages. So 52 pages out of the 100, How many pages they say? Well, they said, I'm sorry. They said 18 volumes, and out of those 18 volumes, there's only 52 pages that constitute for Martinez's testimony. Basically, I guess, they're saying even if they got the whole Martinez testimony out, it wasn't material enough to make Yolanda innocent. So that's why the appellate court is just like, it's not enough, even if they could have done more to look into her criminal history. Her being Martinez, one of the witnesses. Okay, let's see here. For the most part, Martinez's testimony was cumulative of the testimony of other witnesses. Although she was the only witness to hear appellant yell "bitch" at Selena, Martinez was one of several who observed appellant chasing complainant while pointing the pow-pow at her. For these reasons, we conclude Martinez's criminal history is not evidence that creates a probability sufficient to undermine the confidence in the outcome of the proceeding. Appellant also argues that the state's failure to disclose Martinez's criminal record deprived her of the right to cross-examine Martinez and to the effective assistance of counsel. Because evidence of Martinez's conviction was immaterial to the outcome of appellant's trial, we decline to address these arguments. So they're not even entertaining that part of the argument. The trial court did not err in overruling appellant's motion for new trial. Appellant's third point of error is overruled. The next point of error is admissibility of appellant's written statement. In her fourth and fifth points of error, appellant contends the trial court erred in denying her motion to suppress her written statement in violation of her right to counsel under the Fifth Amendment. At a hearing on a motion to suppress, the trial court is the sole and exclusive tier of fact and judge of the credibility of the witnesses, as well as the weight to be given their testimony. The trial judge may choose to believe or disbelieve any or all of a witness's testimony. This court thus is not at liberty to disturb any finding that is supported by the record. Okay, and it says invocation of right to counsel. In her fourth point of error, appellant contends her written statement was inadmissible under the Fifth Amendment because she unambiguously requested an attorney to assist her in questioning before she surrendered to authorities, and the state did not honor her request before obtaining her statement. To effectuate the right against self-incrimination under the Fifth Amendment, police must cease all interrogation once a suspect invokes her right to counsel or until the suspect reinitiates conversation. Consequently, when a suspect has invoked her right to have counsel present during a custodial interrogation, a valid waiver of that right cannot be established by showing only that she responded to further police-initiated custodial interrogation, even if she has been advised of her rights. A person invokes the right to counsel when she indicates that she desires to speak to an attorney or have an attorney present during questioning. An invocation must be clear and unambiguous. The mere mention of the word attorney or lawyer without more does not automatically invoke the right to counsel. So that's good to know, y'all. At least back in 1998, just mentioning attorney or lawyer is not you invoking your right to counsel. The right to counsel is not inherent within the Fifth Amendment, but a prophylactic measure provided under Miranda v. Arizona. Therefore, the prohibition against continued questioning following an invocation of the right to counsel is justified only by reference to its prophylactic purpose. Accordingly, a court must focus on whether a suspect actually invokes her rights. The inquiry is purely objective, whether a reasonable officer in light of the circumstances would understand the statement to be a request for an attorney. Consequently, when reviewing allegations of the right to counsel, an appellate court examines the totality of the circumstances surrounding the interrogation and the alleged invocation. So I would say you might need to go ahead and say, I am no longer speaking. And I know this is easier said than done in real life, but you gotta be so plain, because I feel like the law is gonna err on the side of the officers that are, supposed to support the law, and that's it's not an ideal place to be all the time, but you might want to state plainly, I'm no longer speaking. I need to have a lawyer or my counsel present. And if you still keep answering them, now from what I see from some body cams now, y'all, this ain't all of them, but what I see from body cam now, you can't just nod your head. You have to say you understand and let them know, do you want counsel or do you want to proceed? That's what I see now from body cams. And with this being back in 1998, I don't know. I'm just stating my opinion. I'm gonna keep moving because, That's my opinion. I'll just leave it there. Hey, I'm his hood thing found. Who is that? Is that Kim? Okay. So then it says, at the pretrial hearing on appellant's motion to suppress her confession, Sergeant Paul Rivera testified that he instructed the personnel with the negotiating team to bring appellant to the police station so that we could talk to her. He said upon her arrival, she was placed in an interview room and warned of her constitutional rights. Rivera further stated that appellant voluntarily initialed the warnings read to her from a police form and indicated she understood the rights. Thereafter, appellant gave her written statement. After hearing other testimony and argument, the trial court denied appellant's pretrial motion to suppress her written statement. In its findings of fact and conclusions of law, the trial court found appellant knowingly, intelligently, and voluntarily waived her rights and gave a statement to police. During trial, the trial court reconsidered appellant's motion to suppress after admitting audio tapes made during the parking lot standoff and after hearing the testimony of two members of the special negotiation team who facilitated appellant's surrender. Appellant contends the officer's testimony and the following excerpt of the audio tape of the negotiations reflects her clear and unequivocal invocation of her right to counsel. So this is now a little bit of the transcript from the audio. So Yolanda says, Larry, I don't want to live. I don't want to live. Officer Young says, do you want to talk to your attorney? Yolanda starts crying. Officer Young says, I'm reading exactly as it's written in the transcript. When you come out of the truck, do you want to call him first? Richard Garza. Yolanda is crying. Officer Young says, isn't that what you said his name was? Yolanda said, yes. Officer Young said, you want to talk to him first? Yolanda said, yes. Officer Larry Young, a member of the negotiation team, acknowledged that he offered to call an attorney for appellant, but testified that he did not promise appellant an attorney as soon as she surrendered to police. Okay, well, he did. Okay, I'm gonna keep going. Young said he fulfilled all of his promises to appellant except letting her use the phone. Officer Isaac Valencia, another member of the negotiation team, testified that the team offered to call an attorney because appellant needed to have a hope to talk to somebody else. During negotiations, Valencia talked with Richard Garza, an attorney who had represented appellant's family in other matters. Valencia said Garza was apprehensive about talking to him, but assisted him after Valencia stressed that he was not conducting a criminal investigation, but gathering personal information to build a rapport with appellant. Both officers testified they did not attempt to procure an attorney for appellant after her surrender. After hearing argument outside the jury's presence, the trial court denied appellant's motion to suppress her written statement. In its findings of fact and conclusions of law, the trial held the negotiations with police during the standoff did not constitute custodial interrogation, and the appellant never clearly and unambiguously invoked her right to counsel during the standoff. Reviewing the record in light of the totality of the circumstances surrounding the parking lot standoff, we find the record supports the trial court's findings of fact and conclusions of law. The record reflects that appellant did not clearly and unambiguously invoke her Fifth Amendment right to counsel as provided in Miranda. At most, the negotiation team offered her an opportunity to talk with an attorney. Moreover, appellant did not invoke the right to counsel during custodial interrogation as required by Miranda. Although appellant was clearly surrounded by police and could not escape the parking lot during the standoff, she was armed and not restrained. The communications between the negotiation team were clearly not intended to elicit an incriminating response. The negotiations regarding her surrender, therefore, cannot be characterized as custodial interrogation. Because she did not invoke her right to counsel, police officers acted properly by providing her with the Miranda warnings and obtaining a waiver of her rights before initiating custodial interrogation at the police station. Accordingly, we overrule appellant's fourth point of error. Misstatement of statutory warning before interrogation. In her fifth point of error, appellant asserts her confession is voluntary and therefore inadmissible under Article 3822 of the Code of Criminal Procedure. Appellant claims officers Young and Valencia violated these provisions when they repeatedly told her during negotiations that they wanted to help her, that it was in her best interest to publicly tell her story, and that the Lord himself wanted her to publicly tell her story. In spite of the inappropriateness of these warnings, appellant asserts the trial court admitted her written statement over objection. Appellant, however, did not urge an Article 3822 objection or constitutional objection to the admission of her statement at trial on the grounds that officers Young and Valencia misstated the warnings before or during custodial interrogation. Appellant urged an Article 3822 objection at the pretrial hearing on the motion to suppress her written statement regarding proceedings that occurred after the police administered the warnings at the police station. The trial court heard no evidence regarding the standoff negotiations at the pretrial hearing. Appellant voiced another objection to the admissibility of her statement after the trial court admitted the audio tapes and the testimony of officers Young and Valencia. At the hearing, outside of the jury's presence, appellant objected to the admissibility of the statement on the ground that she invoked her right to counsel during the standoff and the state dishonored her request. The trial court entertained no objection and heard no argument regarding the officer's allegedly inappropriate warnings at this hearing. Finally, appellant re-urged all of her previous objections when the trial court admitted her written statement. Because appellant did not object at trial on the ground she now asserts on appeal, she waives review of this point of error. Accordingly, we overrule appellant's fifth point of error. Hold on, did she say? Oh, is it okay? That is Kim. Okay, hey Lisa, if I didn't say hey. Okay, that is Kim. All right. Then it says evidence of extraneous misconduct. In her 6th through 11th points of error, okay, so it's 6 through 11, appellant complains of trial error in admitting evidence of extraneous misconduct and in failing to give the jury a limiting instruction regarding extraneous misconduct. In her 17th point of error, appellant contends she is entitled to a new trial because the documents related to the extraneous offense were lost or destroyed without her fault. And hold on. Is that it? Oh, okay. I was about to say. All right. So admissibility of extraneous misconduct evidence. An appellate court reviews the trial court's decision to admit or exclude evidence under an abuse of discretion standard. Therefore, as long as the trial court's ruling is within the zone of reasonable disagreement, the appellate court will not intercede. In point of error 6, appellant contends the trial court abused its discretion in admitting evidence of extraneous misconduct because the state did not give adequate timely notice as required by Rule 404B. Former Rule 404B prohibits the admission of evidence of extraneous offenses committed by the defendant for the purpose of providing her character by showing she acted in conformity with that character on the occasion in question. Evidence of extraneous misconduct is inadmissible, however, to show proof of motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident, provided that upon timely request, the state provides reasonable notice in advance of trial of its intent to introduce evidence of the extraneous misconduct in its case in chief. At a pretrial hearing on discovery motions held 2 months before trial, appellant asked the trial court to rule on her 404B motion requesting notification of the state's intent to introduce evidence of an extraneous offense in its case in chief. At that time, the state indicated its intent to introduce evidence that Quintanilla thought appellant was embezzling funds and confronted her about it. Because the record reflects that appellant received reasonable notice as required by Rule 404B, we find the trial court did not abuse its discretion in admitting extraneous offense evidence. Appellant's 6th point of error is overruled. In her 8th point of error, appellant contends the trial court abused its discretion in admitting evidence of extraneous misconduct during the guilt-innocence phase of the trial because the evidence was irrelevant and prejudicial and the state did not prove embezzlement beyond a reasonable doubt. To preserve error in the admission of extraneous offenses under the rules of evidence, the opponent of extraneous evidence must first object under Rule 404B. The state must then show the proffered evidence is relevant apart from its tendency to show that the defendant is a criminal. So again, pulling back to the YSL trial, when they had their, what was the rule for cumulative and waste of time. You know, they objected during trial. They had their objections every time. So I understand that you definitely, I'm not gonna say definitely, but through YSL trial, we have seen that um, the attorneys have to make their objection known while it's happening if they believe that, and apparently the Court of Appeals is saying you can't wait until now to say that you thought that was extraneous evidence. Right. Kim said, after love, I will always see the state is crazy. Yeah. Yep. Oh, you always look at the state crazy. I got you. Okay. So it says, at the defendant's request, the trial court should then require the state to articulate the limited purpose for which the evidence is offered. In making a determination as to the relevancy of the evidence, the trial court must, under Rule 104B of the Rules of Criminal Evidence, determine at the proffer of the evidence that a jury could reasonably find beyond a reasonable doubt that the defendant committed the extraneous offense. If the trial court determines the evidence is irrelevant or is relevant, the defendant must further object under Rule 403 and obtain a ruling as to whether the probative value of the evidence is substantially outweighed by its prejudicial effects. Appellant did not raise a Rule 404B or a Rule 403 objection when Quintanilla testified at trial that he thought appellant was embezzling funds from the Selena fan club. Instead, appellant objected that she had been denied discovery of the records supporting Quintanilla's testimony. Appellant did not raise a Rule 404B or Rule 403 objection to the testimony of Chris Perez, complainant's husband, and complainant is Selena. There it goes, that 403, Kim, yes. Who testified that he and complainant removed appellant from complainant's checking account because they did not trust her. Moreover, appellant did not object on the basis of Rules 404B and 403 to the testimony of complainant's sister, Suzette Arriaga. Arriaga testified over a hearsay objection that complainant intended to fire appellant because she thought appellant was embezzling funds from Selena's company. Consequently, appellant failed to preserve error to the admission of extraneous offense evidence. Appellant's eighth point of error is overruled. In points 10 and 11, appellant contends the trial court erred by not giving the jury a limiting instruction regarding the extraneous misconduct as required by Rule 105A of the Texas Rules of Criminal Evidence, and by refusing her request to instruct the jury in the court's charge as to the limited use of the extraneous offense evidence and the standard of proof it must apply in considering the evidence. Okay, before I even read this next part, and I haven't read ahead, we also saw during the YSL trial that you have to request a limiting instruction, or we saw during the YSL trial that they requested limiting instructions during trial. There's always some, with the law, sometimes there's always workarounds, so I'm not going to say that they have to, but that's what we saw during YSL. They had to constantly argue and fight for limiting instructions for the jury. Kim said, I believe there were more people involved in funds being got. Probably, it probably wasn't just her. Okay, so it says former Rule 105A requires the trial court, upon request, to restrict evidence to its proper scope and to instruct the jury accordingly when evidence is admitted for limited purposes. Abner v. State, extraneous offenses are admitted for a limited purpose. Defendant is entitled on timely request to instruction by the trial judge to the jury limiting its consideration of the extraneous offenses to those purposes for which they are admitted. Moreover, if the defendant so requests at the guilt-innocence phase of trial, the trial court must instruct the jury not to consider extraneous evidence admitted for a limited purpose unless it believes beyond a reasonable doubt that the defendant committed the extraneous offense. A party opposing evidence, nevertheless, has the burden of objecting and requesting a limiting instruction. There it goes. At the introduction of the evidence. So we all had some law school during the YSL trial, didn't we? Because it says that they have to request it at the trial when the evidence is introduced. So there we go. So then it says, once evidence is received without a proper limiting instruction, it becomes part of the general evidence in the case and may be used as proof to the full extent of its rational persuasive power. Once admitted, evidence that might have been inadmissible for certain purposes, if the proper objection had been made, is not limited in its use. In this case, appellant did not make a proper objection to the admission of unadjudicated extraneous offense evidence and did not request a limiting instruction when the state proffered the evidence at the guilt-innocence phase of trial. Therefore, appellant forfeited any error, and the trial court admitted the evidence as probative of any question to which it was relevant. Thus, the trial court did not err by not charging the jury with a limiting instruction regarding extraneous offense evidence. We overrule appellant's 10th and 11th points of error. In point of error 9, appellant maintains the trial court erred in admitting harmful hearsay regarding extraneous misconduct in violation of her right to confront and cross-examine witnesses as guaranteed by the United States and Texas constitutions. Appellant specifically complains about the admissibility of Perez's statement that Selena did not trust appellant and Arriaga's testimony that complainant or that Selena was going to fire appellant because Selena thought appellant was embezzling funds from her company. The state contends the appellant did not preserve error in both instances. In the alternative, the state contends Arriaga's testimony was admissible as an exception to the hearsay rule. On direct examination, Perez testified that he and Selena removed appellant as a signatory to complainant's business checking accounts. When asked why they removed appellant as a signatory, Perez testified over a hearsay objection that Selena and I didn't trust her being Yolanda. Then, without further objection, Perez testified as follows. Question: why didn't you trust her? Answer: because there was a lot of things that were coming up, unaccounted for, and we couldn't get an explanation that we were satisfied with for some of those things. Question: and do you remember approximately how long before she was unalived, approximately? And he asked that we did that, and the question says that you removed her from the accounts. And Selena's husband says maybe about 2 weeks. The question was asked, did you fire Yolanda? And he says, yes, we did. I remember there was a phone conversation where Selena said that she couldn't trust her anymore. It was after that meeting that took place at the shop. Generally, a party waives error regarding improperly admitted evidence if the same evidence is later admitted without objection. Okay. It says, House v. State, stating an error in allowing inadmissible evidence is cured when the same evidence comes in without objection elsewhere in trial. So you have to basically stay sharp, because if they scooch that evidence in another way, it stays. Is according to this. Oh my God, I can't think of the word. It's not history. It's, oh my gosh, where's DG? What's the word? Oh my gosh, when you can show through previous trials that something was ruled similarly, and you can then use that to support your current fact. And I can't remember the phrase. Oh my gosh. If y'all remember, let me know. But it says, in this case, Perez repeated his previous statement that complainant did not trust appellant without objection. Therefore, it is of no consequence whether Perez's testimony constituted inadmissible hearsay because appellant did not properly preserve error. On the other hand, appellant preserved error as to her claims that Arriaga's testimony constituted inadmissible hearsay. Following Perez's testimony, Arriaga testified about the meeting in Selena's office when Selena confronted appellant about the fan club discrepancies. Arriaga testified she spoke with complainant Selena in her home a week or so after the meeting. When the prosecutor asked Arriaga about her conversation with Selena, appellant objected to the testimony as hearsay and requested a limiting instruction. The prosecutor argued Arriaga's testimony was an exception to the hearsay rule as a statement of complainant's emotional intent or state of mind. Hey T. Roberts, miss you too. I'm back. You see, I'm back. I got a different format for now, but I'm back. Good to see you, T. Roberts. So it says, outside of the jury's presence, the trial court heard argument from counsel regarding the testimony. Appellant's trial attorney argued the testimony was clearly hearsay as follows. So this is a quote. It's clearly a hearsay statement of Selena. Selena's not here for us to cross-examine. It is not a present sense about the offense itself, which is when that rule can come into play. Going to fire doesn't have anything to do with the shooting, and I object. We can't cross-examine Selena. She's not here. She's not available as a witness. Both sides agreed the statement, "I'm going to fire Yolanda," was a statement of what Selena was going to do, although they disagreed whether the statement went to Selena's state of mind. The trial court overruled the objection. Arriaga then testified that Selena said that she was going to fire Yolanda because she thought she was embezzling from her company. Hearsay is a statement other than one made by the declarant while testifying at the trial or hearing offered in evidence to prove the truth of the matter asserted. And just to catch you up if you just came in, I'm reading the 1998 appeal decision of the Texas Court of Appeals when Yolanda tried to appeal her conviction. Okay. It says hearsay is inadmissible at trial, except as provided by statute or by the rules of criminal evidence. Former Rule 8033 of the Rules of Criminal Evidence provides for the admissibility of a statement of the declarant's then existing state of mind, emotion, sensation, or physical condition, such as intent, plan, motive, design, mental feeling, pain, or bodily health. It does not permit a statement of memory or belief to prove the fact remembered or believed. In this case, Arriaga's statement consists of two distinct clauses. In the first, Arriaga states complainant told her she was going to fire appellant. Although appellant specifically objected to this clause at trial on the ground that the statement did not go to Selena's state of mind, she conceded the clause was a statement of what Selena was going to do. Texas courts have admitted as an exception to the hearsay rule state of mind statements looking into the future. I'm skipping over some of the citations. Moreover, complainant's intent to terminate appellant's employment was relevant to show the state of the relationship between Selena and Yolanda at the time of the shooting and to establish a motive for the shooting. Therefore, the statement was admissible as a state of mind exception to the hearsay rule. The second clause of Arriaga's statement that complainant thought appellant was embezzling from her company does not fall within the Rule 8033 exception. Instead, the clause denotes complainant's belief about appellant's past actions, which Rule 8033 specifically prohibits. Therefore, the trial court abused its discretion in admitting the second clause of Arriaga's statement. Nevertheless, our review of the record in its entirety leads us to conclude that the error did not affect a substantial right of the appellant. A substantial right is affected when the error had a substantial and injurious effect or influence in determining the jury's verdict. There are several reasons the admission of Arriaga's statement is harmless. First, her testimony regarding Selena's belief that Yolanda was embezzling funds was brief. The state did not offer any documentary evidence to support Arriaga's embezzlement allegation and did not pose any additional questions to Arriaga regarding the allegation. Second, any potential harm was diffused by other evidence which the trial court admitted without proper objection. For instance, Quintanilla testified that he confronted Yolanda in complainant Selena's presence about discrepancies in fan club records and his intent to pursue the matter legally. Perez also testified that he and Selena did not trust Yolanda because Yolanda could not give an adequate explanation to their questions regarding business matters. He further testified that Selena fired Yolanda. Third, the state did not emphasize Arriaga's statement in closing argument at the guilt-innocence phase of trial. Instead, the prosecutor recounted Arriaga's testimony as follows. Also, Suzette testified to you that Saturday before Selena was over for dinner over at her house, and Selena told her that she was planning to fire the defendant because she thought that something was going on, but there was some evidence that she needed to finish that business in Mexico. Even if the jurors considered Arriaga's statement, it is unlikely they would have placed any substantial weight on it. Accordingly, the admission of this evidence was not substantial or injurious. Appellant nevertheless contends the admission of Perez's and Arriaga's testimony violated her rights under the Confrontation Clause of the United States and the Texas Constitutions. Hearsay, even if admissible under one of the evidentiary exceptions, may violate the Confrontation Clause of the Sixth Amendment to the United States Constitution and Article 1, Section 10 of the Texas Constitution. And y'all remember when Attorney Brian Steele argued about the Confrontation Clause, about some of the, for instance, I can't remember his name now. There were so many, but the one that they basically pulled out of the hospital to come testify, but then he got so sick, the defense could not cross-examine him, I believe. Was that, or they were preparing in case they couldn't cross-examine him, Lil D or something like that. I can't remember the name. It's so many names now, but that's how I remember the Confrontation Clause, because of that part in the YSL trial, and then also with the unfortunate unaliving of I guess names are not gonna come in my memory today. That's what's gonna happen. Zachary. Okay, that was Zachary. That he got sick, and yes, okay. And then who was the one that unfortunately was unalived, but he was most likely on that witness list though? I can't remember his name right now, but he's very famous too. But y'all, let me know, y'all, because I want to complete the thought, but I can't remember I can't remember his name right now. Okay, so was it Quan? Okay, Rich Homie Quan. Thank you. Yes, they were saying Confrontation Clause. They couldn't obviously have an opportunity to cross-examine, but they still the state had inserted some things about Rich Homie Quan and stuff like that. Okay, thank you, because that was gonna stay in my brain, so thank you. Okay, so it says, let me get my place back. I should have been marking it with a pen. Y'all, look at my pens. Hold on. Look, I got my little cute pens. I love these things. I should have marked it though. So it says, appellant nevertheless contends the admission of Perez's and Arriaga's testimony violated her rights under the Confrontation Clause. Hearsay, even if admissible under one of the evidentiary exceptions, may violate the Confrontation Clause of the Sixth Amendment to the United States Constitution and Article 1, Section 10 of the Texas Constitution. It says, hold on, I'm skipping citations. Appellant, however, objected at trial on the ground of hearsay, not on the ground that the admission of hearsay violated her right of confrontation under either the state or federal constitutions. Therefore, appellant did not preserve error for appellate review. Accordingly, we overrule appellant's ninth point of error. So they maybe would have had to look into it more if they actually said they objected under a Confrontation Clause versus just it being hearsay. Hey, Auntie Natty, how you doing? It's good to see you, Auntie Natty. Okay, discovery of extraneous offense evidence. In point of error 7, appellant contends the trial court abused its discretion and violated Article 39.14 of the Code of Criminal Procedure by denying her pretrial request for discovery of Selena fan club records, specifically those Quintanilla acquired shortly before Selena's unaliving from the current fan club president. Appellant also argues the trial court erred by overruling her request for production of the documents as required by Rule 611 of the Rules of Criminal Evidence when Quintanilla testified about fan club records at trial. Because she was denied discovery of these documents, appellant claims she was denied due process of law, the right to confront and cross-examine witnesses, and the effective assistance of counsel. When Quintanilla testified, he believed appellant was embezzling funds from the fan club. Before we go on, by the time we get to the Court of Appeals ruling, I see the pattern. The pattern is there was a lot of arguments that needed to be made during trial, and they're not objecting to the right clauses, like the Confrontation Clause and things like that, when they have to do it at trial. So since her overall appeal was denied, which we know because we're here in 2025, I'm just seeing the pattern though, like, okay. It says a defendant in a criminal trial does not have a general right to discovery of evidence in possession of the state. See Kinnaman v. State. It says Article 39.14, however, provides limited discovery independent of the constitutional right of access to exculpatory evidence. Nevertheless, decisions involving pretrial discovery of evidence which is not exculpatory, mitigating, or privileged are within the discretion of the trial court. Article 3914 provides that upon a timely motion showing good cause and notice to the other party, the trial court may order the state to provide discovery of designated documents, papers, written statements of the defendant, books, accounts, letters, photographs, objects, or tangible things not privileged, which constitute or contain evidence material to any matter involved in the action, and which are in the possession, custody, or control of the state or any of its agencies. In this case, the trial court permitted appellant and the state limited discovery of complainants, which would be Selena's, business records that were in Quintanilla's possession by means of a subpoena ducis tecum. At the trial court's request, Quintanilla turned over 2 boxes of business records to his attorney, who remitted the boxes to the state. Quintanilla stated that he thought the fan club records were in one of the boxes. The trial court inspected the boxes in camera and disclosed several documents to both parties, but did not disclose the fan club records to either party. Appellant tendered the documents in her possession to the trial court as Court Exhibit 1, but neither party ever offered the documents at trial. The undisclosed documents remaining in the 2 boxes after the trial court's inspection were not offered into evidence or placed in the trial court's file and are not before this court. As a general rule, evidence willfully withheld from disclosure under a discovery order should be excluded from evidence. See Pena versus State. There is no evidence the state willfully withheld fan club records from appellant. Moreover, there is no evidence the state ever possessed the records or had access to the records apart from those the trial court disclosed to appellant. Instead, the record reflects that the trial court exerted its discretion in providing limited discovery of Selena's business records after reviewing the content of the boxes in camera. Because the documents and records were Quintanilla's private papers and not part of the state's file, we cannot say the trial court abused its discretion in disclosing the documents in Court Exhibit 1 to both parties and declining to disclose others. Appellant also contends the trial court abused its discretion in denying her request for production of Selena fan club records when Quintanilla testified at trial. Former Rule 611 of the Texas Rules of Criminal Evidence provides when a witness uses a writing to refresh his memory for the purpose of testifying, either while testifying or before testifying, an adverse party is entitled to have the writing produced at the hearing to inspect it, to cross-examine the witness thereon, and to introduce in evidence those portions which relate to the testimony of the witness. I'm marking my spot this time. Hold on. Okay, so obviously, call back to YSL trial. That's when we heard a lot of times the defense attorneys would say, I think the defense attorneys would object, and then the state would have to clarify, are you reading from your record right now, and let us know when you're done refreshing your memory. And of course, the defense side had the opportunity to inspect what the officers and the experts were using to refresh their memory and all that. So definitely remember that. It says, nevertheless, appellant is only entitled to fan club records if Quintanilla actually used the records to refresh his memory. In this case, there is no evidence that Quintanilla used the fan club records to refresh his memory during or before his testimony. Outside the jury's presence, Quintanilla testified about the specific documents he thought were proof that appellant was embezzling funds, but he never stated that he used those documents to refresh his memory at any time. Therefore, appellant's contention under Rule 611 must fail, because the trial court did not abuse its discretion in denying appellant's pretrial discovery request for fan club records and her request for the documents during trial. We overrule appellant's 7th point of error. Oh, you tapped the tip jar? I'm using my phone to record. I'm gonna have to check it when I get off. But I thank you, T. Roberts. I appreciate that. Tapping the tip. I love how you put that. I tapped the tip jar. Thank you. Limiting instruction extraneous offense. In her 12th point of error, appellant alleges the trial court did not properly inform the jury regarding the voluntariness of her conduct by overruling her objection to paragraph 6 of the jury charge and by refusing a requested instruction on the issue. When reviewing charge errors, an appellate court must undertake a 2-step review. First, the court must determine whether error actually exists in the charge, and second, the court must determine whether sufficient harm resulted from the error to require reversal. In defendant's objections to the charge, appellant specifically objected to paragraph 6 of the court's charge, which applies the law to the facts of the case. Now, if you believe from the evidence beyond a reasonable doubt that Yolanda Saldivar, on or about March 31st, 1995, did then and there intentionally or knowingly caused the unaliving of an individual, Selena, by shooting Selena with a firearm, or that the defendant on or about March 31st, 1995, did then and there with the intent to cause serious bodily injury to an individual, Selena, do the act of shooting Selena with a firearm, that this act was clearly dangerous to human life, and that this act caused the unaliving of Selena. But you further find from the evidence, or you have a reasonable doubt thereof, that the defendant did not voluntarily engage in said conduct, as that term has been defined above, then you will find the defendant not guilty. I agree, T. Roberts. Over money and being fired, she takes a life. I agree with you. She did not have to do that. That is not, no, that's not the way to go. It says, appellant argued the paragraph did not adequately apply the law to the facts as proven in the case because it did not limit the jury's determination of voluntary conduct to her specific conduct at the time the pow-pow discharged. Appellant asserted that the facts reflected at the time of the fatal shot, she was threatening self-unaliving by holding a loaded, cocked revolver to her head, and the pow-pow discharged as she waved it toward the door in her motel room. So if you came in later, one of the things that was read was that Selena had her back to her. She was heading out of the motel room, out of the door, and she was shot in the back. Yolanda is over here trying to say she was going to shoot herself, but she was waving it erratically, and it happened to discharge and shoot Selena. That's what she's trying to say, in my opinion, on how I'm reading it. Personal interpretation. It says, appellant requested the following instruction regarding voluntariness of her conduct. This is what she requested. You are instructed that a person commits an offense only if she voluntarily engages in conduct, including an act, an omission, or possession. Conduct is not rendered involuntarily merely because the person did not intend the results of her conduct. Now, if you believe from the evidence beyond a reasonable doubt that on or about the 31st day of March 1995 that Selena suffered injuries from a firearm and that she was unalived as a result thereof, but you further find from the evidence, or you have a reasonable doubt thereof, that Yolanda, while threatening self-unaliving and holding a loaded, cocked firearm to her own head, waved the gun toward the door, and in doing so the firearm involuntarily discharged, thereby causing the injuries to Selena, then you will find the defendant not guilty. So apparently that's how she wanted it worded. Tracy, I'm done with you. Tracy, don't come in here kicking the door in. That's what they said earlier too, Tracy. And hey, they said that Yolanda might be safer just staying in there, staying on ahead and stay in there. Okay. The trial court overruled the objection to the charge and refused the requested instruction, which, yeah, I would, if I was a judge, I would not let you rewrite that charge that way. Like, there's no way. No, I would not let you rewrite that charge like that. So, on appeal, appellant asserts paragraph 6 is defective because it informs the jury not to consider voluntariness unless and until it is convinced appellant acted with the intent or knowledge that the unaliving would occur, thus precluding a juror wavering on intent from considering the voluntariness issue. Appellant claims her requested instruction cures the defect because it informs the jury that if it believes the death occurred, it may consider the voluntariness of the act which caused the death. But it can't, no, because that charge, the way I read it, that they wanted it written, was you only could conclude she accidentally did it. No, Proof of both a culpable mental state and a criminal act committed voluntarily are necessary to support criminal liability. It says the issue of the voluntariness of one's conduct or bodily movements is separate from the issue of one's mental state. I'm about to Adonandus v. State, only if the evidence raises an issue regarding the voluntariness of the conduct charged must the trial court instruct the jury to acquit if there is reasonable doubt as to whether she voluntarily engaged in the conduct of which she is accused. It says C. Brown v. State. In this case, the trial court did not err in instructing the jury in paragraph 6 of the charge and in refusing appellant's requested instruction. The record reflects the state charged appellant with the unaliving by shooting Selena with a firearm. The trial court instructed the jury to find appellant guilty if it found beyond a reasonable doubt that appellant committed the act of shooting Selena with a firearm with the requisite mental state. It further instructed the jury to acquit appellant if it found she did not voluntarily shoot Selena with a firearm. The charge did not condition the jury's consideration of the voluntariness of the act of shooting complainant on whether it also found appellant had the culpable mental state to commit the act. Appellant's requested instruction, on the other hand, summarizes facts derived from trial testimony, which Article 36.14 specifically prohibits. So she can't, the way she was trying to twist it, it was already prohibited anyway. Accordingly, we overrule appellant's 12th point of error. All right, now we're on to lost exhibits. In her 17th point of error, appellant contends she is entitled to a new trial because original documents, specifically those related to the extraneous offense of embezzlement tendered to the trial court at a pretrial hearing for in-camera inspection, have been lost or destroyed without her fault. At the time of appellant's trial, Rule 50E of the Texas Rules of Appellate Procedure provided as follows. When the record or any portion thereof is lost or destroyed, it may be substituted in the trial court, and when so substituted, the record may be prepared and transmitted to the appellate court as in other cases. If the appellant has made a timely request for a statement of facts, but the court reporter's notes and records have been lost or destroyed without appellant's fault, the appellant is entitled to a new trial unless the parties agree on a statement of facts. T. Roberts says she never deserves to come home no matter how they write it. It says, appellant believed the state planned to charge her with embezzlement or introduce evidence at the murder trial that she was embezzling funds from the Selena fan club. To prepare her defense, appellant filed a discovery motion requesting the state to produce documents and papers that the state obtained from appellant and records, documents, or summaries upon which a claim can be made that appellant was embezzling money from Selena. She sought the production of similar documents from complainant's father, from Selena's father, Abraham Quintanilla, by means of a subpoenas ducis tecum. Quintanilla filed a motion to quash the subpoenas. After an evidentiary hearing, the trial court ordered Quintanilla to turn over records regarding Selena business entities to the trial court. Quintanilla turned over 2 boxes of documents to his attorney, who remitted the boxes to the trial court. A few weeks later, at a hearing on another motion, the trial court granted appellant's request that the state produce documents that were obtained from appellant except for papers belonging to Quintanilla. At the same hearing, the trial court denied appellant's request for documents or summaries upon which a claim could be made that appellant was embezzling money. Appellant then requested the trial court to seal the 2 boxes of documents obtained from Quintanilla if the court was not going to inspect the documents. The trial court took the request under consideration and indicated that it would inspect in camera the records from Quintanilla. A month later, at another pretrial hearing, the trial court indicated that it had reviewed 2 boxes of Quintanilla's documents and would turn over 1 or more documents to the state and to appellant. T. Roberts said, this is sad all over again. It's like waking up a sleeping bear. Yeah, it is. I agree. It says, at trial, Quintanilla testified he believed appellant was embezzling funds from the Selena fan club and confronted her about his suspicions. Outside the presence of the jury, Quintanilla stated he based this belief on a letter appellant had written to Bank One of San Antonio and on forged checks which were payable to appellant. He said he gave the fan club records to his attorney, and he thought his attorney gave them to the trial court. He further stated that of the 2 boxes turned over to the court, 1 box contained the checks and the letter appellant wrote, and the other boxes contained records of another Selena business entity. Yes, Sexy RN says this appeal, the way the Yolanda's appeal is reading is gaslighting. It's the Pow Pow's fault. It's Selena's fault. It's everyone else's fault but the person who brought the weapon and pulled the trigger. Right. Right. And yep, American Born says she definitely plays victim. Yeah, she does. Um, Yolanda, girl, just stay in there. Just stay in there. Under oath, one of appellant's trial attorneys testified the appellant had not received Selena fan club records, although appellant had received some records of another Selena business entity. The trial court stated it had inspected the 2 boxes of documents on 2 occasions and turned over to appellant all matters to which the trial court believed she was entitled. The trial court also indicated it reviewed other fan club records that it declined to turn over to appellant. Following a brief recess, appellant's trial counsel tendered the records that the trial court had provided to appellant as Court Exhibit 1, but the documents were not admitted into evidence. The trial court sentenced appellant on October 25th, 1995. Appellant filed for a motion for new trial and arrest of judgment on November 22nd, 1995, alleging she was denied the effective assistance of counsel because the trial court refused to allow discovery of financial records relating to allegations of embezzlement. On December 5th, 1995, Quintanilla appeared on a television show with the forged checks and the Bank One letter to support his claim that appellant was embezzling funds from the Selena fan club. A videotape of the television program and an English translation of the transcript of the program were admitted as defense exhibits. The trial court denied the motion. On August 3rd, 1996, appellant filed with this court her third motion to supplement the record with the originals of all sealed records that were produced by the state and complainant's father for in-camera inspection. On August 8, 1996, this court ordered the trial court to certify and transmit all sealed records produced by the state and by complainant's father for in-camera inspection and all records relating to embezzlement charges, which the trial court turned over to appellant and were admitted as Court Exhibit 1. The trial court clerk informed this court that appellant's criminal file and exhibit file did not contain the documents requested. On October 15, 1996, appellant filed a motion to supplement the record with affidavits of various court personnel stating the sealed records produced for in-camera inspection were not in the trial court's possession. Appellant alleged the documents had been lost or destroyed without her fault. On November 14, 1996, the state filed a motion to supplement the record with affidavits, one of which stated that Court Exhibit 1 had been located and forwarded to this court. Because other documents produced by the state and by complainant's father for in-camera inspection had not been located, we ordered the trial court to conduct an evidentiary hearing to determine whether any portions of the record were missing and whether they were missing without appellant's fault. After an evidentiary hearing, the trial court made the following findings of fact and conclusions of law. So we're going to go over the findings of fact. See, Roberts, I'm done with you. I'm done with you. Okay, so findings of fact. After reviewing those portions of the statements of fact and transcripts submitted to this court as DX 1 through 8, the court finds that those portions of the record do not support appellant's contention that some exhibits have been lost or destroyed. Specifically, though, there are several references in the statement of facts and transcript to number 1, the documents subpoenaed from Abraham Quintanilla. Number 2, the mental health records of Rosario Garza. Number 3, the records of attorney Albert Huerta. And number 4, a manager for life contract. Appellant never made these documents part of the trial record for appellate review. Number 2, no manager for life contract ever existed. Number 3, first of all, manager for life contract, that sounds illegal anyway. What do you, girl, a manager for life? No, that I feel like that could have been voided out if it had existed. And I guess in perpetuity is maybe what it said, but either way, no. Other than the documents subpoenaed from Abraham Quintanilla and Court Exhibit Number 1, appellant made no inquiry as to any other missing documents prior to the hearing. The clerks of the 214th and 228th district courts never had custody or possession of whatever it is that appellant contends is lost or destroyed. Appellant never requested that they make it a part of the record. The official court reporters of the 214th and 228th district courts never had custody or possession of whatever it is, not whatever it is, that appellant contends is lost or destroyed. Other than Court Exhibit Number 1, these items were never marked, offered, or admitted into evidence. Court Exhibit Number 1 has not been lost or destroyed. The documents submitted to the court by Sergeant Joel Castaneda for in-camera inspection, not all of which are in Court Exhibit Number 1, were given to appellant's counsel. All exhibits which were properly marked, offered, and admitted into the record are accounted for and are in the custody of the 14th Court of Appeals. Whatever it is that appellant contends is lost or destroyed, other than Court Exhibit Number 1, was never properly marked for identification or admitted into evidence. Appellant never made a formal or informal bill of exception regarding whatever it is that appellant contends is lost or destroyed. The great bulk of material that remained in the courtroom and the surrounding area after the trial was removed to the office of appellant counsel by delivery service. Okay, let me read that sentence a different way. The great bulk of material that remained in the courtroom and the surrounding area after the trial was removed to the office of appellant's counsel by a delivery service. Exact copies of the documents subpoenaed from Abraham Quintanilla have been substituted in their entirety for the purposes of this hearing only. The court instructed the clerk and or other court personnel to make the documents subpoenaed from Abraham Quintanilla a part of the record. This specific instruction is not part of the record. Both clerks and the official court reporter of the 228th District Court specifically recall not having been instructed to do this. The court learned at this hearing that it is the custom and practice in Harris County to require a written order to facilitate the inclusion of in-camera documents in the court's file. Appellant made a timely request for a complete record. Conclusion of law. Because of Texas R. App P50D places the burden squarely on the appellant rather than this court to see that a sufficient record is presented to show error requiring reversal, appellant is not entitled to a new trial because whatever it is that appellant contends is lost or destroyed were not admitted exhibits. Sexy RN said, not knowing her, Yolanda is a narcissist, controlling, and has antisocial personality disorder. She lost control of Selena and ended her. I don't even think it was about the money. Oh. No, you're on to something, Sexy RN. I don't think it's just about the money either. I have to agree with you. People get obsessive over losing access to people. So I'm gonna have to say I agree with that it wasn't just about the money or about the money at all. Yeah, I can see your point for sure. Okay. I should have marked my spot. Hold on. There exists a paucity of appellate and or statutory guidelines for the proper handling of a paucity of appellate and or statutory guidelines for the proper handling of in-camera records. Appellant does not specifically dispute the trial court's findings of fact and conclusions of law on appeal. Instead, she makes a general assertion that some of the original papers and exhibits on file or admitted at trial were lost or destroyed without her fault. After reviewing the record, we perceive nothing that shows the trial court abused its discretion in making its findings of fact or drawing incorrect conclusions of law from the findings of fact. None of the documents that form the basis of appellant's complaint were admitted as evidence or placed in the trial court's file. Consequently, none of the documents were ever part of the record. Therefore, Rule 50E affords appellant no relief. Accordingly, we overrule appellant's 17th point of error. So had the state tried to admit or say that they had forged checks, because that's something she said was missing, the forged checks, the manager for life contract, had they still tried to introduce that as evidence and it was logged, then she might have had a fighting chance on that one, but they didn't even try to say they had that in evidence, use that, in testimony and stuff like that. So the court's like, no, it does not. One, they're like, at this point, the appellate court sounds like she's making up the documents in the first place. That's kind of like where it seems like they're at in their ruling. And also, since it wasn't admitted, it didn't do anything for or against her because it was never even played upon in front of the jury or whatever. That's how I'm taking it. Okay. Commitment on failure to testify. In point of error 14, appellant contends the trial court committed reversible error in overruling her objections and denying her motion for mistrial based on the prosecutor's comments on her failure to testify. Quote, the purpose of closing argument is to facilitate the jury in properly analyzing the evidence presented at trial so that it may arrive at a just and reasonable conclusion based on the evidence alone and not on any fact not in evidence. Campbell v. State, to be proper, jury argument must encompass one or more of the following. 1. Summation of the evidence presented at trial. 2. Reasonable deduction from that evidence. 3. Answer to opposing counsel's argument. Or 4. A plea for law enforcement. A comment on the defendant's failure to testify violates the privilege against self-incrimination contained in the Fifth Amendment to the United States. I actually want to I'm ready to see the court's opinion. I know that either way her appeal was denied, but I'm ready to see why they denied this one, because I'm interested in a closing argument the state bringing up someone's failure to testify, because I know you can't do it during the trial, because they tried to do something like that with Shannon Stillwell, right? About how he testified or didn't want to testify at first when one of the young ladies was unalived in that vehicle, or he was in custody, and somebody refused. They didn't want to testify at that time, and so I remember the state was trying to get that in there, and the defense was sharp. I'm talking about YSL trial, just in case you came in. The defense was sharp, and they caught that, and it's like you can't try to use that to make them look guilty because they didn't want to talk to the police or something like that. I remember that moment. But anyway, it says, to determine whether a prosecutor's remark constituted an impermissible reference to an accused's failure to testify, we consider whether the offending language, when reviewed from the jury's standpoint, was manifestly intended or of such a character that the jury would necessarily and naturally take it as a comment on the accused's failure to testify. Montoya v. State. It says, overruled on other grounds by Cockrell. Oh, sorry, that was the reference. See Montoya v. State. And, okay, it says, it is not sufficient that the offending language might be construed as an implied or indirect allusion to the defendant's failure to testify. The implication that the offending language made reference to the failure to testify must be a necessary one. On the other hand, language that can reasonably be construed to refer to a failure to present evidence other than from the defendant's own testimony does not amount to comment on failure to testify. In applying the standard, we consider the facts. In applying the standard, we consider the facts and circumstances of each case to determine whether the language used was an impermissible comment. So case by case basis, it looks like appellant complains of the following two arguments in which the prosecutor commented on appellant's failure to give an adequate explanation for her actions. So there's a Mr. Skirka. Hey, Brittany Janae, beautiful, how are you? There's a Mr. Skirka, and it says, Mr. Quintanilla suspected Yolanda of a lot of things and confronted her with it in front of Selena and in front of Suzette. What's happened. She was never able to give a satisfactory explanation. She could never explain why these people that sent in their money hadn't gotten anything. Mr. Skirka. And again, you've got a registered nurse here, folks. Somebody that knows about reporting this kind of stuff and documenting this evidence and everything. How come she doesn't report it down in Mexico? How come she doesn't do that? How come she drives her sister back to San Antonio and then comes back to Corpus and never reports it? The trial court overruled Yolanda's objection to each argument. Neither argument in this case was a comment on her failure to testify at trial. Okay, that's good because I didn't take it as that either. The first argument was a summation of the evidence. Quintanilla, Arriaga, and Perez testified that appellant was unable to give an adequate explanation for fan club discrepancies and other document discrepancies when confronted with their suspicions. The second argument was a rhetorical question based upon a reasonable deduction from the evidence. Rhetorical questions are generally within the scope of jury argument, so as long as they are based upon a reasonable deduction from the evidence. A rhetorical question, however, may constitute an impermissible comment on the failure to testify if it is accompanied by a statement pointing to the lack of an explanation. In this case, the prosecutor's argument was based on a reasonable deduction from the evidence. Patricia Norma Biggs, the director of the emergency room at Doctors Regional Medical Center in Corpus Christi, testified that complainant brought appellant to the hospital because complainant is Selena, so it says the nurse, no, The director of the emergency room testified that Selena brought Yolanda to the hospital because Yolanda said she had been raped by two men the day before in Mexico. The hospital was unable to assist Yolanda in reporting the rape because it occurred in Mexico. As a courtesy, Biggs arranged for evidence to be collected at the University Medical Center in San Antonio because Yolanda was from San Antonio. From this testimony, the prosecutor questioned why Yolanda, who was a registered nurse, waited to report the rape. Oh, okay, so Yolanda's a registered nurse. Okay, or was. The prosecutor did not say, however, that an explanation had not been given. In this instance, the prosecutor properly used a rhetorical question to persuade the jury that the rape and appellant's theory of the case were untrue. Appellant also complains of the following argument. Okay, so this is another transcript piece. It says, Mr. Valdez is saying, you know why he said things like that. There's a reason for it. To take your mind off the real issue in this case. Take your mind off the real person who's at fault right there. The one who stands up defiantly every time they point to her, she stands up defiantly. She doesn't say anything, but she looks at you and she's very defiant to everybody who points at her. That's the one who's responsible and she's guilty. Appellant Yolanda, however, did not object to the argument. A defendant's failure to object to a jury argument forfeits her right to complain about the argument on appeal. Because appellant did not object, she waived any possible impropriety of this argument. Finally, appellant argues the trial court erred in denying her request for a mistrial after sustaining her objection and instructing the jury to disregard the following argument. Okay, so Mr. Valdez is speaking again. He says, and the only thing that he has going is that he says the tapes prove it was an accident. They don't. He says Robert Garza proves it was an accident. It doesn't. It's not any evidence of accident. What kind of evidence is there in this case? What kind of evidence is there that this was an accident? When you think about it, there isn't any. There's no evidence. The only evidence so far are the tapes, and on the tapes, the defendant says she didn't intend to do it, that the gun went off accidentally. That's the evidence. Now, if that proved that a shooting was an accident, we'd never have any unaliving prosecutions. Never. If anybody who shot somebody else just had to come in and say it was an accident and that proved it, we couldn't prosecute anybody. That's the only evidence they have besides the ranger who says he heard her say that the gun went off. Once again, the record reflects that during closing arguments, one of appellant's trial attorneys argued the state could not prove his case against appellant because the testimony of Robert Garza and the hostage negotiation tapes revealed the shooting was an accident. Appellant's trial attorney argued the state had attempted to minimize the importance of the tapes and Garza's testimony at trial because they were devastating to his case. He further argued Garza's testimony and the tapes were credible evidence because the state could not present evidence without vouching for his credibility. The trial court overruled the state's objection that appellant's trial attorney misstated the law. Appellant's trial attorney then argued Garza's testimony and the tapes were credible as follows. They embraced it, and so they brought you, by embracing it, evidence that has to create a reasonable doubt. Because credible evidence on that tape, time and time again, consistently unrehearsed, in an emotional state, not planned, not trying to excuse, says, this was an accident. It was unintentional. I didn't intend to hurt her. I didn't intend to shoot her. They brought you and embraced credible evidence which cannot now be discounted by you. They may not like it, but they chose, because of that tactic, they chose to put themselves in a position where each of you can walk back there and say, yes, there is a reasonable doubt. I don't even really have to go any further than that because there is a reasonable doubt. And you say not guilty when you do that, and you come right back. After reviewing the record, we find the prosecutor's comments in this instance were not outside the bounds of proper jury argument. Instead, the prosecutor's comments were an answer to the argument of opposing counsel and a comment on appellant's failure to provide additional evidence to support her theory that the shooting was accidental. Even if the prosecutor's argument could be construed as a comment on appellant's failure to testify, the trial court's instruction to disregard the statement cured any error. So the judge instructed them to disregard that statement. Okay. Because the trial court did not err in overruling, Let me just read it. Because the trial court did not err in overruling appellant's objections to comments made by the prosecutor during closing arguments and did not err in denying appellant's motion for mistrial, we overrule appellant's 14th point of error. Prejudicial opinion testimony. In her 13th point of error, appellant maintains the trial court abused its discretion in admitting irrelevant and prejudicial opinion evidence during the punishment phase of trial. Appellant specifically objects to the testimony of Dr. Faustino Gomez, a San Antonio dermatologist. Outside the jury's presence, Dr. Gomez testified that he employed appellant 12 years ago as a medical receptionist and bookkeeper, but he terminated appellant's employment when he discovered she misappropriated $9,200 from his business. So Yolanda wasn't new to this, she was true to this. Over objection, Dr. Gomez testified before the jury that in his opinion, appellant was not a law-abiding citizen. So the jury didn't even hear, according to this at this time that I'm reading it, the jury did not even hear that she worked for him and she stole $9,200 or misappropriated $9,200. What the jury did hear was that she was not a law-abiding citizen. On cross-examination, he admitted he had not seen appellant in 10 years. Appellant argues Dr. Gomez's testimony should be inadmissible because his opinion is based on an experience that occurred 12 years ago. Appellant acknowledges that former rules 404 and 405 of the Rules of Criminal Evidence regarding character evidence are silent as to the remoteness of the underlying events giving rise to opinion testimony. Nevertheless, she contends the 10-year rule governing impeachment evidence under former Rule 609B should apply to character evidence admitted for punishment purposes because an opinion based on a remote transgression is a poor indicator of present character. A plain reading of Section 3A of Article 3707 does not invoke the restriction that appellant invites us to apply. Article 3707 simply does not address the effects, if any, of a statute of limitations for previous criminal offenses or the staleness of bad acts. So just because something like that occurred 10 plus years ago, it didn't grow stale and now it can't be, all of a sudden you can't use it. That's how I'm paraphrasing what I'm understanding. Moreover, appellant cites no authority, nor have we found any, to support a holding restricting the admissibility of opinion evidence during the punishment phase to opinion based on offenses or acts less than 10 years ago. To the contrary, the plain language of the statute supports a broad interpretation in favor of the admissibility of all relevant evidence unless the probative value of the evidence is substantially outweighed by its prejudicial effect. Oh, y'all, I just remembered that word from 30 minutes ago. I was trying to think of when they call back to previous cases to help them do a current argument. Precedents, setting precedents. That's what I was thinking of. Okay, going back. It says Article 3707 expressly provides during the punishment phase. Oh, let me make sure I'm on the right part. Yeah, expressly provides during the punishment phase the state or the defendant may offer evidence as to any matter the trial court deems relevant to sentencing, including but not limited to the defendant's general reputation, her character, and an opinion regarding her character. Moreover, Section 3A of Article 3707 empowers the trial court with authority on the threshold issue of admissibility of relevant evidence during the punishment phase of a trial. An appellate court reviews such evidence under an abuse of discretion standard. Therefore, as long as the trial court's ruling was at least within the zone of reasonable disagreement, we will not intercede. See Montgomery v. State. Recognizing that reasonable men may disagree whether in common experience a particular inference is available. A trial court abuses its discretion if by no reasonable perception of common experience it admits evidence that is not relevant by any reasonable interpretation, or if what appears to be common experience is really no more than the operation of a common prejudice not borne out in reason. Article 4 of the former Texas Rules of Criminal Evidence addresses relevancy and its limits. Former Rule 404C of Article 4 provides that the prosecution or the accused may offer evidence of the accused's prior criminal record or other character evidence during the penalty phase of trial. Former Rule 405A permits either party to provide proof of character by reputation testimony or opinion testimony conditioned only on the witness's familiarity with the reputation of the accused or with the underlying facts or information upon which the opinion is based prior to the date of the offense. In either case, the trial court may permit inquiry into relevant specific instances of conduct on cross-examination, and misappropriating of someone's funds you worked for definitely seems relevant to me, in my opinion. In this case, the trial court held a hearing outside the jury's presence to consider the relevancy and admissibility of Dr. Gomez's testimony. After hearing Gomez's testimony of the facts underlying his opinion and considering the argument of counsel, the trial court permitted Gomez to tell the jury that in his opinion, appellant was not a law-abiding citizen. We find the trial court's ruling was at least within the zone of reasonable disagreement under the applicable rules of evidence. Thus, we will not intercede. Appellant's 13th point of error is overruled. Okay, now she's arguing sudden passion. Instruction on sudden passion with adequate cause. In her 15th and 16th points of error, appellant claims the trial court erred in denying her request for an instruction and a special issue regarding sudden passion as permitted under Section 1902D of the Texas Penal Code. It provides in relevant part as follows. At the punishment stage of a trial, the defendant may raise the issue as to whether he caused the unaliving under the immediate influence of sudden passion arising from an adequate cause. If the defendant proves the issue in the affirmative by preponderance of the evidence, the offense is a felony of the second degree. So how do you go from I was about to unalive myself and I was waving the pow pow to it was a crime of passion? So you did. All right, Yolanda. Okay. It says the existence of sudden passion is simply a mitigating factor relevant to punishment, and the burden of proving sudden passion by a preponderance of the evidence during the punishment phase rests on the defendant. The current definitions of sudden passion and adequate cause are identical to those set forth in the former voluntary manslaughter statute. Therefore, we rely on prior decisions under the voluntary manslaughter law for guidance. An accused is entitled to an instruction on every defensive issue raised by the evidence, whether the evidence is strong, weak, contradicted, unimpeached, or unbelievable. Consequently, if the record reflects any evidence that appellant acted under the immediate influence of sudden passion arising from an adequate cause, the trial court should submit an instruction on this mitigating circumstance. Appellant maintains her written statement raises the issue of whether she caused complainant Selena's unaliving under the immediate influence of sudden passion arising from adequate cause. Appellant contends she became enraged after Selena told her that Selena's father accused her of embezzlement and sexual deviance, and subsequently argued with Selena, which immediately escalated into an unaliving. Where'd the sexual deviance come in? That's just me asking myself that question. But it says appellant attested in the statement to the following in pertinent part. As Selena was driving me back to the motel in her truck, she told me that her father had told her that the papers I had brought from Monterey were wrong and that her father had said that I was, a lesbian. So the sexual, okay, all right. So I'm rainbow friendly over here. So if that's what they're trying to call sexual deviance, I'm not with it. But yeah, okay. It says I got mad and I told her that I did not want to work for her anymore. So now Yolanda's saying she didn't want to work for Selena anymore. We got to the motel and we both went inside the room and we both argued because I wanted to quit working for her. I gave her everything that I had, the cell phone and the bank files as we argued. She started dumping all the files on the bed from the briefcase or handbag that I had. I took the pow-pow from my purse, which I had brought about 2 weeks ago in San Antonio for $250. I took the pow-pow from my purse and Selena started walking towards the door, which was opened. Y'all, she literally says, yes, give it up, Yolanda. That's news to me too, American Born. Give it up, Yolanda. Okay, so this is where now y'all know earlier her argument was voluntariness and she's waving it that she was gonna unalive herself and it accidentally discharged and it pow-powed Selena in the back. Now, from what I'm reading on here, it says I took the pow-pow from my purse and Selena started walking toward the door, which was open. I pulled the hammer back and I pow-powed at her as she was walking towards the door, which was open. Sudden passion means passion directly caused by and arising out of provocation by the victim or another acting with the victim, which arises at the time of the offense and is not solely the result of former provocation. Good morning, Miss PewDiePie. Miss PewDiePie. Good morning, Miss Cutie Pie. Okay, it says, in other words, sudden passion is an excited and agitated mind at the time of the unaliving caused by an act of the deceased. Adequate cause is cause that would commonly produce a degree of anger, rage, resentment, or terror in a person of ordinary temper sufficient to render the mind incapable of cool reflection. In this case, appellant's written statement does not raise the issue of sudden passion arising from adequate cause. While the statement shows that complainant Selena provoked appellant's anger by telling her about Quintanilla's accusations and that they argued over her continued employment, it does not reflect evidence of the extreme emotional and psychological state defining sudden passion or adequate cause. Shooting an employer and friend in the back as she walks away from an argument is not an objectively common response in an ordinarily reasonable person. The murderous acts of one not of ordinary temper or whose response to the alleged cause is not objectively common in the ordinary reasonable person does not support a voluntary manslaughter issue. Willis v. State. In other words, voluntary manslaughter is not available to one whose actual emotional responses are aberrational in this society. Because appellant's written statement did not raise the issue of sudden passion from adequate cause, the trial court did not err in overruling her objection to the jury charge and refusing her requested instruction on the issue. Accordingly, we overrule appellant's 15th and 16th points of errors. Finding no reversible error, we affirm the judgment of the court below. All right. So they basically upheld the court's decision, and then let me see. It might be up under all of this. The last thing is, so now, Yolanda is going for parole. And so it says parole review status. The parole review process begins approximately 6 months before the parole eligibility date for a first review and 4 months before the eligibility date in additional reviews. The process begins with the offender's file being reviewed for all, including letters of support and protest. An institutional parole officer reviews the file and interviews the offender before preparing a case summary for the board voting panel. The board normally will vote on the case just prior to the parole eligibility date. Offenders eligible for mandatory supervision who committed an offense since September 1st, 1996 are reviewed for discretionary mandatory supervision. An offender who has received a serve all vote is reviewed for possible release to DMS by a board panel prior to being released on the projected release date. So it says this offender has not been reviewed for parole, and next parole review date is March 30th, 2025. Woo! So shout out to y'all for hanging in there with me. So the long part was her 1996 appeal and a detailed review of how the Texas Court of Appeals came to the decision to not try to reverse the conviction, or however they would word it. So I hope y'all enjoyed that new format for a while. Don't know how long, but here I am. So I will get back with y'all on Naziah Harris, hopefully. I won't say next, but I just will get back with y'all on Naziah Harris's case and maybe some other things as well. But I thank y'all for your time. Y'all hung in there with me. I appreciate it. All right. Until next time, I will see y'all later. Bye.